Hello, my name is Nick Price. I'm a partner in Osborne Clarke's commercial disputes team. I focus on financial litigation and compliance, including sanctions. I'm joined today by Kristian Assirati, who is an associate director in the commercial disputes team, who does complex international litigation and also focuses on sanctions. So, we've just passed the second anniversary of the start of the war in Ukraine. And since then, we've seen a massive expansion of the UK sanctions regime, particularly as it pertains to Russia. We've seen a large expansion in the scope of particularly financial sanctions and also business services being supplied to Russia and the restrictions there. We've also seen a big expansion of the process of OFSI's guidance on the way it will approach sanctions, as well as the introduction of strict liability in summer 2022. And there are still developments changing now. We are seeing new bodies being introduced, new approaches to guidance as well. And whatever the impact of the UK sanctions regime on Russia, which is of course the intended target, the most common questions we are seeing from our clients are about the impact on UK companies. And the point of a sanctions regime is to restrict otherwise legitimate activity. And from a Russian perspective, that's to encourage those who are impacted to change the behaviour of the Russian state. But that works both ways. There is otherwise legitimate behaviour of UK companies which has been restricted. And today we're going to talk about some of the most important and some of the more recent changes and the impact that that is having on UK companies. Now, Kristian, we've talked a lot, and people do talk about the expansion of OFSI's enforcement powers and the bases on which they can take enforcement action. So, what enforcement activity are we actually seeing?
Well, Nick, over these last 2 years since the invasion of Ukraine, I can tell you that there has been very little by way of enforcement action on the financial sanctions side. It's remarkable, really, because if you think back to June 2022, when you had the introduction of strict liability, what happened there is the government changed the game, and they said, if you breach sanctions, we will fine you, even if you don't know or have any reason to suspect that you are breaching sanctions. So one would have expected there to be a lot more enforcement action than you've seen. What you do have is one decision by OFSI, the HMRC agency for the enforcement of sanctions, that has rendered one decision against a company called Wise Payments, and that was in relation to a withdrawal of £250 from a business account. Now, the owner of that business account wasn't sanctioned, but the owner of that owner had been sanctioned the day before, or a couple of days before. So what happened there is there was a breach of sanctions, but what happened next was OFSI didn't levy any form of financial penalty. What they did is they censured Wise and they said, you breached sanctions, but it's relatively low value, so we'll give you a little slap on the wrist, not much more. And that's really it. And the message really coming out of that is there's no de minimis, so £250 payment, very small in the grand scheme of things. There's no real grace period. These were sanctions that came in a couple of days before, over the course of a weekend. You could be forgiven perhaps for not picking that up immediately. No, you can't be forgiven for that, OFSI says. So that's where we are on enforcement.
That's interesting, because of course that's enforcement against a UK company, and it sounds like the message to the market there is we're going to censure and say there is no de minimis, there's no time delay. But I think it's interesting that we're seeing potentially a change in approach away from UK companies onto designated persons, because traditionally that otherwise legitimate activity I was talking about, designated persons themselves, they are impacted by it, but they have no responsibilities under the UK sanctions regime. And that's changed. In December, a new regulation came in that said all designated persons must disclose all of their financial resources in the UK, or if they're in the UK worldwide, within 10 weeks. And of course, that came in just before Christmas. That 10-week period is now over. And I wonder if that low level of enforcement activity has generated the desire to expand the scope of the regime and result in a change in approach.
So speaking of change in approach, Nick, you've seen this very much on the trade sanctions front as well. So traditionally trade sanctions, and by that I mean the prohibitions on UK businesses exporting certain goods and services to Russia. On that side, there's been a big development too. So back in December last year, the government announced the creation of a new body to enforce trade sanctions. That body is called the Office of Trade Sanctions Implementation, OFSI for short. And that body will become responsible for the civil enforcement of trade sanctions. So there's a question there over whether that will lead to more enforcement, or is it all about sharper messaging? Hopefully there'll be a bit more clarity coming out of it, is all I'll say. But I do wonder, Nick, do you think that the lack of enforcement that we've seen could be indicative of a, for example, properly functioning licensing system?
I mean, it's an interesting question, Kristian. I think the answer is probably no. The licensing regime with OFSI has seen significant criticism over the last 2 years. I mean, there has been a lot of delay where applications have been made for licenses. And just to be clear, when we say licenses, this is an application to OFSI to say this would otherwise be a breach of sanctions, and I would like there to be an exception here. But there were significant delays. We were seeing delays in the many, many months, even for a response. And since then, OFSI has significantly increased its workforce size, and there has been some improvement. But it is still quite a slow system. And even once you've got through it, we're seeing a very, very low level of approvals. I think the numbers for last year were just 24 out of 500 applications. And I do wonder whether the reason for that is that the criteria for a license being granted are very narrow. You're looking at humanitarian grounds, you're looking at exceptional circumstances. But actually, as we've discussed, there are a number of impacts on UK companies' business as usual, where that otherwise legitimate activity is being restricted, and it is being restricted in circumstances where it doesn't really further the sanctions regime. I'm sure we can go on and talk about some specific examples, but I do wonder whether there is a model in the AML regime that could be followed here, which is defences against money laundering, where you can write to the relevant body there, which is the NCA, and say, look, we're aware of this conduct, we're aware that it would be a breach of the AML regime, can we please have an exception here? And that function's very well developed, and I think it works well, and it allows there to be more exceptions where it benefits UK businesses. But right now what we have is delay and uncertainty, and I think that is the core problem.
Yeah, I think that it makes really good sense, Nick, and that I think uncertainty manifests itself in a number of different ways in the sanctions regime. One thing that we've seen a lot of is this issue over uncertainty over the control test for sanctions. So I mentioned earlier that a business that is not designated will still be subject to sanctions if it is owned or controlled by a designated person. And what we've seen is that causing a lot of difficulties for businesses working out what control is. And there was a pretty big case last October, wasn't there, Nick, where the Court of Appeal came out and said that there was a much broader concept of control than had previously been understood to be the case. What the court said was, in that case, President Putin and the governor of the Central Bank of Russia was acting in a position of control over the central bank. That, perhaps unsurprising, given that it was the governor of the central bank, so I see that. But then the court went further. It said that President Putin could potentially be deemed to control everything in Russia, all businesses, on the basis that the Russian economy is a command-control economy. He has power there to control everything, is essentially what the court was getting at. Now, that decision set a lot of worries, led a lot of problems for businesses working out what they were going to do. Were they going to consider all Russian businesses off limits? the position has moved on a bit now. That appeal, the appeal court decision, has now been appealed to the Supreme Court. We're waiting for a decision on that. OFSI gave some guidance which said that they didn't think that that interpretation was correct. Interesting approach from a government body questioning the decision of the court, but there we are. So where we are is there's quite a bit of uncertainty still remaining over this concept of control, which is incredibly critical to a business's understanding of where and when sanctions bite.
I think what's particularly concerning about the Minsk decision and that area of case law is that it focuses on the central bank of Russia. And the UK government has specifically not designated the central bank of Russia, although, as you say, it has designated its governor. And the reason for doing that is that the Central Bank of Russia is like the UK Treasury. It is like the tax-raising body. It carries out the financial services of the state. And the key difficulty we're seeing here is that even where the UK sanctions regime is working, where UK companies are deciding to withdraw their business from Russia, to exit Russia, and no doubt having the impact on the Russian economy that the UK government want to see, they are now having to pay exit taxes to the Central Bank of Russia. And if the Central Bank of Russia is subject to the sanctions regime, contrary to perhaps the intentions of the UK government, then you have this rock and hard place where companies want to withdraw from Russia but cannot without breaching the sanctions regime. And going back to that licensing, none of the narrow exceptions would apply here, and there is no general license for this. So there is a real impact on firms who want to comply with the regime. Now that's one practical impact. I mean, you do a lot of work in the sanctions area. What other practical impacts are you seeing on UK companies?
Well, I think a lot of it beyond the sort of day-to-day compliance with sanctions and businesses not wanting to be liable for a breach of sanctions, you're seeing this crop up time and time again in commercial contracts where a party has promised to perform something and that performance becomes unlawful under UK sanctions. That causes a whole load of difficulties in supply chain contracts or various different commercial relationships, which is reliant on a party performing in a way that then becomes prohibited. And the way that that works out will very much depend on the way the contract is structured, whether there's a force majeure clause, whether there's a sanctions compliance clause, and failing those, how the doctrines of illegality and frustration work. These are issues that are coming up time and time again in the work we're seeing and in the courts. And beyond that, you're seeing other issues such as the beginnings of sort of shareholder disputes and allegations of breaches of directors' duties, where a director or a company has breached sanctions or there's an allegation of a breach of sanctions. Is that a breach of directors' duties? There are very, very many ways in which sanctions affect the life of a corporate entity and a business, and a number of different ways in which they can be caught out by sanctions. So it's coming up left, right and centre, Nick.
That's really interesting. And I think one that we've seen even before we get to a dispute side is on the private equity side, where you have a very traditional, long-standing Russian investor may only hold a very few percentage points of the overall business. But ultimately, because of the sanctions restrictions, you cannot make any financial resources available, and that includes benefits to their shares. And I think the prevailing view at the moment is that if you're in the same class of shareholders, you can't even vote if the result of your vote would be to potentially benefit this other designated shareholder. And that's putting restrictions on normal restructurings that you might require for new share issues or refinancing or exits. And whilst the UK courts have been quite, I would say, pragmatic in the way they've allowed these schemes to be arranged, it's still a concern that will come up again and again, because these investors could have been involved for many, many years preceding this regime, and now the difficulties are arising where they weren't built into the contracts. No provision was made for this. So I think what we are seeing is more and more impact on UK companies' business as usual. And I suppose the question is, are we going to see something smoother for UK companies in the future? We have seen a promised new approach to guidance from OFSI. We have the new OFSI coming in on trade sanctions. And we've seen a recent refresh on the approach to licensing that OFSI takes, although yet to see that in practice. I think we're all agreed that we need less uncertainty in the way the regime works. But in the meantime, what this actually means for companies is they need to make sure that they have really good systems and controls in place to identify sanctions breaches or potential sanctions breaches. And they need to anticipate any of the unforeseen hurdles that could arise in business as usual. And then, of course, take legal advice to make sure that you are navigating those risks in the appropriate way. Kristian, thank you so much for taking the time to talk through your knowledge today. Really, really appreciate that.
Thank you, Nick.
And thank you very much for joining us.